dispute resolution matters, and this is why. Dispute resolution matters because it takes abstract legal processes and converts them into proactive, practical, relationship-building tools. That is our core belief at the Alternative Dispute Resolution Center. My name is Nanza, the Executive Director at the ADR Center in Kampala. Welcome to the ADR Series. In this season, we are talking bridges. Why bridges and why they matter? ADR Bridges is our segment where we are going to help the user of alternative dispute resolution and the professional understand the gap that we have identified, and together we will find ways to bridge it in order to resolve conflict in meaningful, sustainable outcomes as they sort disputes. In this segment of the ADR Center, we are discussing alternative dispute resolution options. We know it is a very complex subject matter and we appreciate the nuances. But if you stick around for the next while, we will break down from first principles to help you not just understand, but empower you with the options that you have at your disposal when you set out to resolve disputes. As earlier mentioned and previously said, there is a very big difference between settling a case and resolving a dispute. The ADR spectrum, as we have come to know it, just like you know a rainbow, has very many colors that fall into each other. At the very start, which is very common, even in our everyday life, we have negotiations. Negotiations, at the time of negotiation, it could be a doctor trying to convince a patient. We start from the very basic, what the best course of treatment is. You see, already, negotiation is not for lawyers only, negotiation is not profession specific. A parent negotiating with a child on course options, whether at university or career options, would require negotiation skills. But further on at the very end of just the negotiation spectrum, nations resolving geopolitical conflict require negotiations. In my work career, I have seen and understood, by being thrown in the deep end, over 10 years, what a well-prepared negotiation team can achieve, even when the outcome is not desirable. That's how powerful a tool is when harnessed, that it is not outcome-based, but it is relationship-based. We will get further into this discussion as we handhold you and your team, having had a thorough understanding at the point where you are starting out, or bring us on board at the ADR Center to support you with negotiations. Moving further along in the spectrum, we do have mediation. Mediation is the healing, in my opinion, the healing and the calming balm in dispute. But there's a catch. It has to be handled well. I have seen parties that walk into mediation rooms and don't even want to look eye to eye, but with a skill, the hand of a skilled, human-centric mediator, walk away with a resolution that just doesn't resolve the dispute, but leaves the relationship repaired. I will tell you a story at the end of this segment, but let's continue. The next, somewhere in between the middle ground, we have conciliation, neutral evaluation. It does exactly that. When you have your dispute, nobody's telling you what to do. At that point, you know what you set out to do, be it a personal, interpersonal relationship, institution, cooperation, interstate between investors and governments, or even nations. somebody comes and looks outside looking in, no feelings, no emotions, and gives you a fair assessment of what your options are. And that is exactly what we do at the ADR Center. We handhold you institutionally, professionally, corporately, and regionally in the face of dispute to weigh your options and help you chart a meaningful path to wiggle out of a situation, saving time, costs, and relationships. At the other side of the spectrum, we do have arbitration. Every time I have stepped out in any forum, as a thought leader, as an arbitrator, I see the confusion. And sadly, it's not just the users, even the professionals. Can we first clear the air? Not every arbitrator is a lawyer, and not every lawyer is an arbitrator. Actually, the jury is still out there. Lawyers don't necessarily make the best arbitrators because of our training or their training. As we all know, in courtrooms, traditional courtrooms as we know them, is literally a legal showdown. People are coming to win or to lose. If you lose, I win. If I lose, you win. Come to the other side, the bridge that is alternative dispute resolution. Alternative resolution, one, ensures that your linen, your dirty linen, because by the time you go to dispute resolve, things are not looking very good. It is not the smiling handshakes you had at the time of contract signing. So the first course is to repair the relationship, but in the confines of safe space where your trade secrets are safe, where your relationships are not exposed, and where resolution is done efficiently with a bid to create even further collaboration from conflict. Yeah, I know how that sounds, but a well-handled arbitration will deliver a timely, confidential, time-saving, relationship-building outcome. Furthermore about that, when we start our journey with you, if you choose to contact us and understand what ADR options are available for you individually and corporately. My favorite part about this ADR spectrum, it doesn't give you options that are cast in stone. Do you know you can have a combo? There's something called MedUp, where you start with a mediation and see within the confines of the law and procedure, if it doesn't deliver the outcome you want, then you escalate to arbitration. The ADR Center is well equipped. We have done this over decades. We have not only handpicked our teams, but we do have partnerships in institutions, regionally, globally, nationally, where we offer the whole ADR spectrum. The important part I want to bring in when it comes to ADR options is, I promised you a story about mediation, the importance of soft skilling. As earlier indicated, anatomy has tenets even in dispute resolution. And behind every face value of a dispute, there's a psychology to it. You do have to have a particular level of skilling that helps you, one, as a party or as counsel, or even as the arbitrator, mediator, conciliator, adjudicator, to be able to offer a service that doesn't work on the surface level of the conflict, but looks at conflict from the lens of people, relationships, legal, and most importantly, the business. Because at the end of the day, contracts come with money and value that is monetized attached. At the ADR Center, we will handhold you to have a 3D view of your conflict, the people aspect, the legal aspect, and the business aspect. We do look forward to handholding you as we discuss options. Remember, it is option analysis. every conflict is different, every contract has different terms, and every organization has different outcomes they want when they're resolving. In my mediation arbitration practice, a story is told. We won't go into the technicalities of what kind of disputes can be negotiated, what kind of disputes can be arbitrated, adjudicated. That's what we are here for. But I will share a mediation arbitration story that will help us understand and help you understand the layers behind solving disputes outside the traditional court system. There is a family, we will start with the back end, that had gotten into a dispute and had gone to court. And the court, as it is typical in many jurisdiction simply means different countries have different laws that govern how disputes are handled outside the court. For example, in Uganda, we are picking up ADR so much that when you go to court and the judge sees that you have a chance to settle out of court, they encourage you. We do have court-annexed mediations, and the government has been very, very, very instrumental in directing disputes towards that route. One, to reduce the case backlog, but also because of the efficiencies of ADR as we come to learn about them. So this case had gone to court, it's very important to note, and had been sent to mediation. And at mediation, the combo I just spoke about, people did not resolve. These were the facts in the case. Two ladies who had grown up in different phases in their lives. The lady who is what we call the claimant, the one who brought the case, had suffered, unfortunately, sexual assault at the hands of the respondent, the one who had been brought to the dispute resolution arbitration, at the hand of the father. This claimant, or I don't even want to call her a victim, because once you come out and speak about your issues, you're no longer a victim. The claimant in this case had come to ask for compensation many, many years after her abuser had died. What's important to note there quickly is there are disputes that cannot be resolved via mediation and arbitration. So this case was not about a crime of rape or sexual assault as we know it. We will get more into the details. The issue before the arbitration panel, mediation panel, was the abuser's estate. He had died and had left estate and money and to the heir who was his only living daughter. The victim was a stepdaughter whose mother had been in a relationship with this gentleman many years ago. Fast forward, this lady learned that her abuser had died. She had gone through therapy, she had had her own personal relationships. She claims she had not been able to sustain a meaningful relationship as a young adult, understandably so, and had gone through personal trauma and wanted some kind of compensation. Also, it seemed, not just money, but knowing that this abuser had gone and she would probably never have the closure she needed something. This was many, many years later. So when she heard about the estate being left to the sole biological daughter of the abuser, she brought a case to be resolved. As it typical is with mediations, if you're familiar with them, is what they call caucusing. Credit due to the mediator is she had an eye, what I want to call, she read the room, even though with caucusing you deal with one party first, and then you deal with another party, and she had the quick eye, what we call emotional equity, which we are going to empower you with at the center, to sense that the dispute was a lot more about dignity, about closure, than money. It didn't matter the amount involved. Both ladies, as it turned out, were looking for justice beyond monetary compensation. So after the back and forth, what we call caucusing in mediation, she took a step, having heard both parties and understanding what I want to call the gist of the dispute. It was a risky move, and we have to say you have to be very skilled and very emotionally intelligent. Some of the things we're going to teach you at the center, to read and understand where the core of the dispute is. When she went to speak to the other party, the late daughter, the true heir of this estate, she was battle-hardened. Of course, she had lost her father. She was going through legal battles regarding his estate, distributing his things. I think she was not even able to work for some time. She too had her grievances, much as she was the one being brought to book in this particular case. And what is interesting to help us really bring this message home about alternative dispute resolution, at the point where they had reached a stalemate, she was willing to go back to court for litigation, knowing very well that even when she goes to court, the money that is left over after the legal back and forth is not even enough. It is going to reduce her inheritance significantly, but she was willing to make that loss rather than make a concession, because she also thought this lady, the victim, or the one who was abused, was demanding unfairly a part of the inheritance. So back to the skill of the negotiator, the arbitrator, in this case, the mediator, was able to make the parties see that beyond money, the lady who was abused needed a bit of closure and to regain dignity. The lady whose father had died was grieving the loss of her father, the loss of a personal relationship, but a stolen childhood as well. Because remember, while this claimant's mother was with the biological daughter, I think naturally the parents of the girl, the heir, were not together. So for her, she had anger, and it took the skill, that delicate balance of a trained arbitrator, mediator, to bring the parties to see beyond the dispute what money could not make them see. At the end of the day, to cut the long story short, based on the skill and the benefits of ADR 1, the family dignity was preserved. Nobody wants to go to court and hear many, many years later, the one person they call a father or a beloved one, and you hear the things they did that you don't know about, that are going to impact you and maybe your children and children's children if it goes out in the public space. ADR was able to procure confidentiality and dignity. But guess what? When these two ladies, after the separate caucus, were brought together, each realizing what a loss it had been, for the first time the claimant was able to see that she wasn't the only one who had something to lose, which was her childhood and her innocence and the many years of therapy. She was also able to see the conflict through the eyes of the biological daughter, who had lost her relationship and closeness with her dad, who had to now deal with an estate and the financial burden that came with it. And the conflict was moved from what we call a zone of possible agreement to settling for the best alternative, which was not litigation, but one that reserved dignity, respect, time, and even built a relationship. That's the cherry on top for me when it comes to ADR. And that's exactly what the ADR Center will do for you by understanding your conflict and forging pathways and partnerships beyond the ink. Please check out our information to contact us. Go to our website. Go to our YouTube channel for more informative videos like this. Interact with us on the socials, and let's handhold you and walk you through your ADR options for resolution beyond the ink. Thank you so much and have a good day.